I'm Dina Kaplan, and I have a 29-year-old son who's got multiple physical, developmental, and mental health challenges. He had an IEP all the way through school. We were in the Las Virgenes School District, and it was a nightmare. And now he's been out of school since he was 22. And he's not in a day program because we've had a really bad experience with a day program. So I was just telling Sandra I'm starting the process of getting involved in having him in the self-determination program through the regional center. And we're going to try to develop our own day program for him. He requires 2-on-1 care. So I have a nurse and a caregiver every day. And it's challenging, especially trying to work full-time, more than full-time, and juggling everybody's schedules. So I'm hoping that self-determination will help with that. So I'm also an attorney. I've been an attorney for more than 40 years, but I've been doing this area of the law for about 28 years. So after my son was born, I just saw that there was a whole area of the law that I knew nothing about. And I thought, oh boy, if I don't know much about this law and I can't find the information that I need, I'm sure a lot of families who aren't attorneys can't find the information. So that's when I started the K.E.N project, which is a nonprofit organization. And I was just telling Sandra, we used to have in-person meetings through United Cerebral Palsy in Woodland Hills. But since the pandemic, we've been doing our meetings virtually. And if any of you are interested in getting on our email list, what I'm going to do is I'm going to put my email in the chat and send me a direct email. That way it won't get lost. Let me just do that real quick. But what we do is, hold on. What we do is we meet once a month, and I work with an advocate who I've been working with for many years, Andrea Laurent, and the two of us listen to your stories and try to assist you with any issues that you might be having with various school districts, with regional center, with other issues like Medi-Cal and in-home supportive services and things of that nature. And it's a really good meeting, usually. Our next meeting is actually September 13th. So if you're interested, send me a direct email. Let me make sure. Yeah, sometimes I don't know how to spell. So I'm also I had my own practice for many years when Brandon was in school, because I had to drop and run all the time. They would call me constantly. He's done this, he's done that. He pulled out his G-tube, come and fix it, So I didn't think I could work for a firm, but I've known Valerie Vanaman since Brandon was young, because she helped me with him. And I was like, who's this Valerie person I keep hearing about? I need her. And I met with her, and she said to me, look, Dina, you can handle the situation. You're an attorney. And if you need me, I'll get involved. So that was both good and bad advice, because I represented my own child. But we did get a good settlement with our district. And in any event, so I joined Vanaman German about 7 years ago. The timing was right, finally, even though I've known all the attorneys for many years, except for our newest attorney, whose name is Chung Wei. She's Chinese American and brilliant Harvard-educated lawyer. She's our newest associate. The rest of us I've known for many years. And we do almost entirely special education law, but as you probably know, David German branches out into other areas of the law, and he's had some personal injury cases where he's won really big. And there's a lot of information on our website, vanamangerman.com, where you can access information about all of our cases and updates with regard to the law, etc. What I want to do this morning is, I have a PowerPoint, but it's pretty basic information about the IEP process and the Individuals with Disabilities Education Act. And what I want to do is go through it pretty quickly, assuming everyone here has a child with an IEP or has knowledge about the IEP process. So if there's anybody that doesn't have knowledge about the IEP process, can you raise your hand so I can see? Okay, that's what I figured. I figured everybody was pretty knowledgeable. So I'm going to share my screen. Let me get this started. And start this, hopefully. Why is it not doing that? Hold on, there we go. Okay, so this is just information about our firm. We do special education, we do some regional center issues, we do injury and abuse at school issues, and disability and some disability discrimination. But there's been some changes in the law lately that have made disability discrimination cases very, very difficult. So now let me see, next slide. There we go. And that's just the firm and me. And as all of you know, the IEPs are developed through the Individuals with Disabilities Education Act, which was first passed in 1975. So it's interesting to me when I look at that, because not only am I an old person, but when I was in high school, there were no kids with special needs in my school. All the kids with special needs went to a different school and were segregated, which was not the intent of the framers of this law. The intent was to include kids with their typical peers. So I don't know where we went wrong over the years. That's what Sandra and I were talking about, how way back several years ago, inclusion was something that you would talk about, but districts would always say, okay, kid with special needs, a kid with severe special needs to be in a special day class. And it's frustrating, but the good news is we've come very far. And so excuse me, IDEA was reauthorized in 2004 and put higher expectations for children to access the general education curriculum. And the interesting thing is, one of the purposes is to prepare children to lead productive and independent adult lives. So one of the things I find that every district does not do very well is the transition process. And I always tell parents, start young. The law requires the districts to deal with, or at least talk about transition program at the age of 16, younger if the parties agree. So if you have a teenager that's in high school, I would encourage you to start looking at transition possibilities, what your child's going to be doing when they age out of the school system or they graduate from high school. I always thought that it would be so much easier when my son got out of school. I don't find it easier. I don't know, Alma, maybe you, or Sandra, maybe you do, but I don't find it easier. But in any event, start young. That's all I can tell you. So I'm going to jump through some of this stuff. Hold on a second. Everybody, I'm sure, knows that IDEA provides a free, appropriate public education in the LRE, the least restrictive environment. If you have questions, please put them in the chat, and I'm going to leave plenty of time for us to have a conversation after this. So LRE, least restrictive environment, is really important. The other thing is appropriate assessments, and I'll get to that in a second, because that's one of my pet peeves. Then you develop an IEP, individualized education program, from the appropriate assessments. And from that, you determine the goals and objectives. And well, first you determine eligibility, then goals and objectives, and then moving forward, you develop an IEP with a placement and services. So one of the cases that I'm going to talk about, it has to do with the least restrictive environment, and I'm sure that a lot of you have seen it. It is a case that came down in March of 22 and was a case brought by my partner, David German. And he won a case that is so wonderful for families of children that are seeking full inclusion. And that's the DR versus Redondo Beach Unified School District case. And I will talk about that in a little bit. one of the problems I have with assessments, so assessments basically drive the services. And when school districts do assessments on children that can't be, can't take standardized tests, they don't get accurate assessments. This was my pet peeve all the way through school with my son. I have a nonverbal kid who can't, who has what I call, there's a word for it, and I can't think of it at the moment, but he only responds when he feels like it. So a selective response. And he will, if he felt like he was being tested, he wouldn't respond at all. He would just completely shut down. So assessments driving the educational program and the supports that a child receives is hugely problematic on a child who can't be appropriately assessed. And so that's one of my pet peeves in life. And I'll talk about that a little bit more later on when we talk about the Andrew F. case, which was a great case. I'm sure that you know that free appropriate public education means special education and related services that have been provided at public expense, meet the state educational standards, include an appropriate education, and are provided in conformity with the IEP. Now, what that means is every child's education, every child's free appropriate public education is going to be different based on his or her needs. So the Board of Education versus Rowley was the first U.S. Supreme Court case that dealt with special education, and that came down in 1982, and that was our law until 2017. And it basically said the child gets a bare floor of opportunity, meaning if the school district does not have to maximize the child's potential, they only have to give the child a program where they're getting some educational benefit. That was such a low standard for so many years. All the districts were required to do is show that a child was making some progress. So we always argued in cases that it was more than that. And then when the Andrew F. case came down in 22, it confirmed that. And I'll talk about that in a second. Oh, no, I'll talk about it now. So when the Andrew F. case came down in March of 2017, it held that the IDEA requires schools to provide students an education that is reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Now, the last phrase, in light of this child's circumstances, is one of the things that my colleagues and I have been discussing, because going back to thinking what I just said about assessments is, if your child can't be accurately assessed, how does the district know what your child's circumstances are? How does the district know what your child's abilities are if your child can't be appropriately assessed? Now, school district people say, oh, we can assess a child who's nonverbal and who chooses to respond when they want to respond. But I have not seen any assessments that were appropriate for children like mine and probably some of you. So what I've seen in terms of litigation, when we go to due process, is that school districts make the argument that we're providing a program where the child is making progress because that's the best the child can do. And so I really go back and look at the assessments frequently. Now, the question is, well, what can we do about those inaccurate assessments? And the answer is, I don't have an answer. There aren't, so to speak, standardized tests for children like mine and possibly yours. So what I have been arguing for is for basically observations over a longer period of time, instead of one day of testing and trying to get a child to respond when they don't feel like it or they are not interested. Also, we have had situations where we've had testing that was done by a psychologist that has worked with a lot of nonverbal children, and she believes that every child can learn and learn well, and not just barely learn in light of their circumstances. So it's a big issue in light of your child's circumstances. So the best thing that I tell parents is document your child's progress, At home, if you see your child doing something that the school district says he doesn't do, videotape it, show it to them at the IEP meeting. Keeping in mind that videotapes are not admissible in due process proceedings if they're not done with permission. So you can't videotape your child at school without everybody's permission, but you can videotape them at home. And, you know, it's interesting. I frequently get clients who say, well, at school, they'd say that he can't do this, but at home he does it. Or at school, they say he does it, and at home he can't. So I would keep an eye on that. I think that's important. And setting up a paper trail, which used to be a paper trail, but now is a virtual trail through emails, etc., is going to be very important. Communicating with your school and the people who provide an education to your children is going to be very important. And so oftentimes parents will come to me and say, for example, I asked for an IEP 5 times. I asked my child to be assessed at least 5 times. And I say to them, did you put that request in writing? And they say no. And so without putting a request in writing, that doesn't start the legal timelines from running. And so any communication you have with the district, even if it's by telephone, follow it up with an email. I believe that emails do count as a request in writing at this point, and everybody seems to be using emails. But if you are requesting that your child be assessed initially for an initial assessment, I always recommend handwriting or typing a letter and bringing it to the school, getting a copy hand stamped and signed that the date that they received it, because then you know for sure when the legal timeline starts. I'm not real techy, so I like that, you know, delivery better than an email when you're talking about initial assessments. Okay, so let's jump on. Least restrictive environment. It's going to be really important to keep in mind that children with disabilities should be educated with their non-disabled peers to the maximum extent possible. And removal of children from regular education environment occurs only when the nature or severity of the disability is such that education in the regular classes with use of supplementary aids and services cannot be achieved satisfactorily. And that's something that the Ninth Circuit Court of Appeals discussed in David's case, the DR case, which I really want to spend a little bit of time talking about. So I'm going to move forward on this because I think it's pretty basic. There's a whole bunch of related services that are possible. Let's go beyond that. And there's eligibility. And I'm sure you guys all know eligibility. And the change in specific learning disability. Oh, let me go back for a second. Just because a child has an eligibility for special education does not mean that they will be eligible for special education. I've had a lot of kids with autism who are high functioning and who are not in need of special education and related services in order to access their education. So that is something that's a two-pronged thing. You have to have an eligibility that falls within the eligibility categories and be in need of special education in order to be eligible. Section 504 is an anti-discrimination statute, and some kids who do not qualify for IEPs may qualify for a 504, which just provides reasonable accommodations. I'm not going to spend time going over this, but it's in the PowerPoint if anybody wants a copy of it. Evaluations, I just talked about. Send a letter or send it by certified mail or hand deliver to the school, obtain a receipt and keep a copy for your files. So many times parents will say to me, I dropped off a copy of my request and I don't have a copy of it. And then I don't know when the legal timelines start, because if I request records, they usually don't provide me with copies of letters that the parents have sent. Sometimes they do. Legal timeline. School district has 15 days to send you an assessment plan if they agree to assess. If they don't agree to assess your child, then they have to provide you with a prior written notice, which is we refer to as a PWN. And they have to provide a PWN at any time where they agree to do something or disagree to do something that you've requested. So if you've requested an assessment and they say, no, we're not going to assess him or her, they have to give you a prior written notice. And usually when you ask for an assessment, the district will agree to it because most of the time we can make a legal argument that an assessment is required. But keeping in mind, what kind of assessment does your child need? It should be based on all areas of suspected disability. And so you know your child best. You want to ask for a comprehensive psychoeducational assessment, an academic assessment, and possibly an occupational therapy, a speech therapy, a physical therapy assessments. In any event, you have at least 15 days to approve any assessment plan. If you have questions about what assessments are being done, I think it's important to talk to the people that are doing the assessments, again, because you should indicate your concerns, especially if you have a nonverbal child or a child who only wants to participate when they feel like it, and your concerns regarding getting an accurate assessment. The other thing that's important is to ask for copies of the assessment report at least 3 to 5 days prior to an IEP meeting, so you can review them, assessment reports prior to the IEP meeting and be an equal participant in the IEP process. Frequently, I see parents being told that either the assessment report isn't done, or we don't have to give that to you until after the IEP, which is true, sort of, according to the law. They just say it doesn't give you a timeline. It just says that the district has to provide you with copies of your assessment plan, reports. But it puts you in a difficult position if you haven't had the time to review those reports prior to an IEP meeting. So I would tell you to either tell them that you need an hour or two to review the reports and come back to the IEP meeting, or reschedule the IEP meeting. I know it puts the IEP out for a longer period of time, but I really believe that when you're sitting in an IEP meeting, and I know this from firsthand experience, and that they're talking at you about your child and all the things that are wrong with your child, you can't process that and look at a document at the same time. So I think it's very important to get copies of those assessments prior to the IEP. The district has 60 calendar days to complete the evaluations and develop the IEP. That does not include school holidays in excess of 5 days. So that means school holidays like the winter break, like spring break, and summer. They do not have to hold IEPs in the summer. The law says you don't have to hold IEPs in the summer. Usually districts will not hold IEPs during the summer. So I find that everything just sort of stops during the summer. That 60 days is 60 calendar days, like I said. If you request an IEP where there's no new evaluation required, the district has 30 days to hold that IEP. Very frequently, I have families saying to me, oh, I requested an emergency IEP because of what's going on in class, but they are scheduling it 30 days from now. And there's nothing I can do about that. The districts will schedule the IEPs within the legal timelines, and that's 30 days. Okay, I'm not going to talk about that. All areas of your child's suspected disability, we talked about that. So evaluation procedures. Instruments must be free of racial or cultural bias. They must be valid and reliable for the purposes for which they are used. And no single instrument is to be used as sole criterion. And you must consider information provided by the parents. So if parents have a private evaluation, you should always share it with the district prior to your child being evaluated, so that the school district evaluator doesn't repeat the same tests within a short period of time. But I want to go back to the test must be valid and reliable for the purposes for which they are used. this is my biggest pet peeve in life, as I said. And finding assessors who can assess our children appropriately and use appropriate assessments is something that I'm constantly looking for, an assessors that can assess lower functioning children who are nonverbal. So if any of you have had good assessments, please let us know, because I haven't seen any. I was saying, okay, district, you don't know how to assess my child, and so I want you to send him to the diagnostic center. And I don't know if any of you are familiar with the diagnostic center, but there are 3 of them in California that are functioning through the Department of Education, the California Department of Education. And what they do is they are the assessors of last resort. Basically, the district hasn't gotten an appropriate assessment of a child, so they'll refer you to the diagnostic center. And we were there for 3 days. We had a whole bunch of people trying to assess my son, and all he did was act out and refuse to participate. And I got a 50-page report telling me one thing I already knew and nothing that I didn't know. And so they basically said, oh, well, he knows more than we think he does, and he needs to work on his communication. Well, I knew that before I went there, right? So I did not think it was very helpful. In one case I had recently, the diagnostic center's evaluation was pretty helpful. So it really depends on the needs of the child and getting an appropriate assessment. Language an issue. If you have a child whose primary language is other than English, you need to make sure that the assessor provides the assessment in that language. I have a family right now who are refugees from the Ukraine, and the assessor, that psychologist that assessed him, was bilingual and spoke Ukrainian. So that was helpful and an accurate assessment. Okay. Reevaluations. The 3-year reeval, one thing, if you have a child in LA Unified, one of the things we've been seeing lately is the 3-year reevaluation. There's a section on the IEP, and I'm sorry, I don't know what page it is, but it says, does the district and parent agree that a reevaluation is not necessary? And they typically say yes. And when they haven't, they mark yes when they haven't discussed that with the family. And I think it's really important to pay attention to that, because I would tell you that reassessments are definitely necessary every 3 years, and sometimes more frequently than that, depending on what's going on with your child. So I would never waive a 3-year assessment. Okay, and so if they want to exit a child from an IEP or from special education, they have to do a reevaluation before doing that. Okay. Independent evaluations. If you disagree with a district's evaluation, you can ask for an independent evaluation, and the district has to respond in one of 2 ways. They can either agree and give you some parameters as to what the qualifications are of the assessor that's going to be, that you have to, if you want to pick your own assessor, or they'll give you a list of possible assessors who have been vetted and meet the requirements. The big issue is money. They don't pay a whole lot, and most of the assessors that do psychoeducational and psychoeducational assessments charge more than the cap amount, which I think in LA Unified right now is 6,000 or 7,000. It's probably 6,000. But if the district, and in order to ask for an independent assessment, you have to disagree with one of the assessments that the district did. You can't just say, I don't trust you and I want an independent assessment. So for example, if the district didn't do an appropriate speech assessment, you can say, look, this assessment is not appropriate. It didn't get accurate information regarding my child. I'm asking for an independent. The district will say, okay, yes, here's a list of possible speech assessors, or then their other option is to file for due process against you to defend their assessment. Hang on one second. In the past, I would see the districts agreeing right all the time to do IEEs. Now, not so much. Now they're really scrutinizing who they agree to provide IEEs to, independent educational evaluations. So just so you know, if you've gotten your own independent evaluation, and like I said earlier, make sure you share that information with the district, unless it's something that you don't want the district to consider. School records, if you have an IEP, you're entitled to copies of your school records within 5 calendar days of your written request. And I would include all the logs that they keep for services. So behavior logs, speech logs, OT logs, any services that your child gets. Make sure you ask for copies of those if you are asking for records. That's the first thing that we do when we get involved, is ask for copies of records. I think you guys all know what should be in an IEP. So I'm going to skip through some of this. I would like to talk about, hang on. Oh, let's go back a second. Like I said before, one of the matters that needs to be considered by the IEP team is the academic, developmental, and functional needs of the child. So they have to look at whether your child is going to graduate with a diploma, whether they're going to age out with a certificate of completion, and what needs they have in order to prepare them for the future. Okay, present levels, you know this, the contents of the IEP have determination of eligibility, the present level, well, first the present levels of performance, the determination of eligibility, drafting goals and objectives, placement and services, and then any additional supports that are necessary, like a behavior intervention report, a behavior intervention program, so a BIP, if a child's behaviors interfere with his or her access to the curriculum, and a transition evaluation if it is if the child is a teenager, a transition evaluation, and a transition what do they call it? They call it a transition plan, but it's not, they're so bad. They're really, really bad. It's, you know, they don't get accurate pictures. Again, one of my pet peeves, but anyway, if you're in LA Unified, the transition plans have a checklist. And they give the child some options, and they ask the child what they want to be when they grow up, and then they just check off the checklist. And I don't find it very helpful, and it looks the same for every child. So, and I know every child is different. Okay. Oh, testing. So you can opt a child out from regular statewide assessments. Interesting thing that happened on one of my cases recently was the parent opted the child out of the statewide testing, and the district said, well, all children who are opted out are going to take a district test instead. And we said, what? So it was very inappropriate for them to provide the child with a district-wide test because the parent already opted out of those standardized tests, and it wasn't a test for special education. It was just a general test that the district decided to adopt, so that the children whose parents opted them out had a test to take. It was very ridiculous. Let's bounce forward here. Okay, so let's talk about due process a little bit. Which is what our office does. So anytime there's a dispute regarding an IEP, if you disagree with goals, if you disagree with placement, if you disagree with services, anything having to do with that, if you disagree with an assessment, that's when we get involved, and that's when you can access due process. Okay, so in LA Unified, they have an informal dispute resolution process, and they also have what they're calling an alternative dispute resolution process. Those are good if in certain circumstances. If you're not asking for a big ticket item like funding for non-public school or private school, or a ongoing outside program, then you can sometimes get your case resolved through a more informal means. And And frequently I tell families you should do that or try to do that because it takes less time than going through due process. But if you can't do that, then what the process looks like when a family comes to me is I meet with them, I find out what their concerns are, I get copies of all the school-based records, excuse me, I go through all those records and I draft a due process complaint that has their identifying information. It has a statement of facts, a statement of our issues, and what we are asking for in order to resolve the matter. That gets filed with the Office of Administrative Hearings in Sacramento. We call it OAH. And at that point, they administer all of the proceedings for due process in the state. What that looks like is there's 3 parts to due process. The first part is what they call an early resolution session. And that is something that is usually held between the district and the parents. However, if I'm already in due process, I'm not going to let my parents go to the resolution session on their own. The law, when it was reauthorized in 2004, stuck that in there. And I really think they put it in the wrong place if they anticipated parents and district working together without attorneys, because once I've already filed, I cannot ethically let my clients go to a resolution session without me. So the law says, though, that you're not entitled to reimbursement for your attorney's fees for going to a resolution session. So most of the time, what I do is try to minimize the amount of time we spend at a resolution session by sending the other side a settlement demand prior and keeping it to a minimum in terms of time. And then I don't charge my clients for my time in attending those sessions. It's very interesting. The shortest one I ever had was 9 minutes. We had already presented our settlement demand. They asked 2 questions. They said, okay, we'll get back to you. And that was it. So it was, that was good. I didn't have to charge too much. I didn't have to spend too much of my time. Anyway, the second part of due process is mediation. And the mediation process is great. It settles cases about 98% of the time. And I like the mediation process. I'm almost always able to negotiate a decent settlement for the families, and a better settlement, in my opinion, than taking the risk of going to a hearing with administrative law judges who are pretty biased in favor of school districts. We monitor all the cases coming out of the hearing office, and what we have found is oftentimes parents don't win, or most of the time parents don't win. If they win something, they win on an issue or 2, but not all of their issues. And even if they win, they don't get very much. Valerie likes to refer to it as stingy relief, meaning they're not going to give you a whole hell of a lot. So I am almost always able, and my firm is almost always able to negotiate better settlements than we think you would get at a hearing. Does that mean we have to go to hearings sometimes? Absolutely. Sometimes we're so far apart that there's nothing left to do but go to hearing. So if we have to go to a hearing, when you hear the word hearing, think trial, because it's just like a trial. And I think initially in 1975, when the framers of the IDEA were putting it together, I think they thought that parents could resolve these cases in due process on their own. Since that time, it has become very litigious, and I do not recommend any parent going to due process without an attorney. What that looks like for us is there is a fee shifting statute in this area of the law, which means that if we settle favorably or we win in a hearing, you are entitled to reimbursement for attorney's fees. So oftentimes, depending on the needs of the family, I can not charge a retainer. Sometimes I need to charge a retainer, but for the most part, I will work with families if they can't afford to pay a retainer. And I'm sure that the case is going to either get settled or we're going to win in a hearing. I will not take a case that I don't think is a good case, right? So I want to make sure that I'm serving the children as well as my firm and getting reimbursed for our fees. When I say reimbursed, it doesn't mean that you have to pay. It just means that we negotiate our fees with the district. Okay, this one talks about your procedural rights, the resolution session and mediation, and then trial. Like I said, it's called a hearing, but it's a trial. We have to present evidence, witnesses, expert witnesses, and documents, including IEPs and evaluations. It's currently our mediations and our hearings are done virtually like we're doing today. The mediations are great virtually because you don't have to spend time sitting in traffic and everybody can participate. We break off into separate rooms. The administrative law judge helps us facilitate a settlement. If we're not able to settle, that administrative law judge, would not be our judge if the case went to trial. There would be a different judge. The hearings are being held virtually currently, and they are not very good in terms of being able to control witnesses, know what the witness is looking at, having the witness access documents through, it was called case lines, but they changed it to something else. But essentially what happens is we upload all of our documents into this program, and then the witnesses have to access the documents through the program. You know, unless you're pretty tech savvy, it becomes very difficult and cumbersome. In any event, and I find that when hearings were being done in person, I could go up to a witness and say, and point to a document and give them the document and have them read the document. It just had better control. So the other thing you should know about a due process hearing is you have to have expert witnesses to be able to testify on your behalf as to why what the district is offering is not appropriate for your child and why X, Y, and Z is appropriate. Those expert witness fees are not reimbursable to you. So that is the cost of going to a hearing. And it can sometimes be costly if you have a lot of experts. So just be aware of that, which is why, like I said, I like the mediation process. Sometimes if we're not able to resolve in mediation and I get ready for hearing, sometimes I would resolve the cases either right before the hearing or during the hearing sometimes. Okay, so and there's other complaints. The Office of Civil Rights for complaints regarding discrimination, and I'm going to talk about that in a minute. And then a compliance complaint that you as a parent would file with the California Department of Education if the district is not complying with the law with regard to your child's education. Now, there's a lot of crossover between compliance complaint issues and due process issues. And if a parent comes to me who's already filed a compliance complaint and I want to file for due process, what will happen is once I file for due process, the Department of Education will no longer be investigating the compliance issue. So it will all go toward the due process matter. And if the due process doesn't resolve the compliance issue, then the CDE would go back and take a look at the compliance issue. Okay, these are the important cases that I really wanted to talk about and maybe have some discussion about. There was a case that came down called Perez versus Sturgis Public Schools. It came down this year, I don't remember what month, and it held that exhaustion is not required where the relief being sought is not available under the IDEA. So for what that means by exhaustion is when you have an administrative proceeding, you have to what they call exhaust your administrative remedies before you can file in civil court. So, excuse me. So what that means is if you have a case where you're looking for relief under the IDEA, you need to go to, you have to, the way it stands currently is you go to a due process hearing and you exhaust that, and then you can file in civil court. But what Perez said is that if you're looking for relief that's not available under the IDEA, you don't have to go to a due process hearing. You can file right in the federal court. What they're looking at is things that are not available under the IDEA that are available in other matters like damages. So in cases involving due process, what the remedy is what we call compensatory educational services. What that looks like for each child is going to be different based on his or her needs. Now, The compensatory services, it can either be reimbursement to the family or the district contracts with a non-public agency to provide the services. Those are very specific remedies. There's not a lot of remedies available under IDEA. But if you have a discrimination case, for example, that you're seeking damages under that isn't involved with the IDEA damages, or I don't want to call it damages, the IDEA relief, then you can file in federal court. However, the case that came down in 2022, the Cummings case, said the Supreme Court held that a plaintiff cannot seek damages for emotional distress under Section 504, the Anti-Discrimination Act, or the Affordable Care Act. This puts a big damper on discrimination cases, because it's basically discrimination cases, the damages are almost always emotional distress. Sometimes there are some physical damages, or the child has arguably gotten medical treatment that would be medical damages. But for the most part, the damages are emotional. So, and I have families come to me very frequently where they say, I want to sue for discrimination. And discrimination cases, even prior to Cummings, were very difficult to prove, because it usually he said, she said. There's not a lot of documentation, and they're very specific. You have to show intentional discrimination. So in any event, those are two cases. I wanted to talk about this other case. If any of you have children in private school or are anticipating having children in private school and asking the district to pay for it, this is the Capistrano Unified School District case that basically said school districts are taking the position that if a child's in private school because the child was placed in the private school due to a denial of a free appropriate public education, the school district's not going to be on the hook for reimbursing the family for the private school if the family doesn't ask for an annual IEP. The other thing that I'm seeing is districts, and not only LA Unified, I see in other districts as well, and I put it at the bottom, also watch out for annual election letters and make sure you respond that you are requesting an annual IEP for the district to make an offer of FAPE. This case may not affect you guys at the moment, but if it's something that you're thinking about in terms of private school, if you are, there's a notice requirement. So you need to make sure that before you place a child in private school that you give notice to the district if you're asking for reimbursement. And that's something that, our office does routinely. I would tell you, don't do that, and don't place your child without consulting an attorney. Okay. Yay, the best new case. Thank you, David German. So December 20th, 2022, the Ninth Circuit Court of Appeals issued their decision in DR versus Redondo Beach Unified, which clarified core questions around the rights of students with significant support needs to be educated in general education classrooms. And so the decision, I don't know if you are familiar, there was that case that came down years ago called Rachel H. I don't know if I have the actual date, but anyway, Rachel H. came up with 4 factors in determining whether a full inclusion or mainstreaming program would be appropriate for a child. And one of the, let me see if I have the 4. They look at the benefit of the child being the academic benefit the child receives in being in a full inclusion program, the benefit to other children or peers from having that child in the program. It's one of the few areas where they can consider costs. So if it's cost the district a significant amount of money that they're complaining about to fully include a child, then that might be a grounds for not having full inclusion, but I've rarely seen that be an argument. So anyway, so what the decision decisively dismisses are the 2 frequent arguments that schools use to support segregated classrooms. It makes clear that whether or not a student with a significant disability related challenge is performing at grade level academically is irrelevant to the assessment of whether he or she is receiving academic benefit from the placement in the regular classroom. the best part of this, rather, the court held, the question of whether a student is making substantial progress toward meeting his individual academic goals is the core measure of progress. And we look at progress on their goals and objectives. And so often I hear, well, this child's not appropriate for full inclusion because they can't keep up. And that is not a basis for full inclusion. And that's not what full inclusion is all about. When you look at full inclusion, you don't look at whether the child can keep up with what's going on in the academic area of the class. The decision also made clear that the fact that the student needs supplementary aids, supports, and services to access the general education classroom is irrelevant to the analysis of whether he can make academic progress in a general education setting. The need for individual supports, even extensive supports, is not a reason to exclude a child from a general education classroom. So it's really interesting. I've had a couple of attorneys on opposing counsel that represent school districts talk about this case as well. So it's a great case. It is the Ninth Circuit, for those of you who don't know, is specific to Western states, and I don't know all of them, but California, Nevada, Washington, Oregon. So this is not a case that will apply in other circuits that are not part of the Ninth Circuit. So I think that I have in here my contact information, which I gave you. Our website is simply vanamangerman.com. We have a couple of advocates in our office. We have one that works through our office whose name is Jaime Hernandez. If you want to work with an advocate, or there's two other private advocates that I work with frequently. And advocates generally, advocates are not lawyers, but they generally have a good understanding of the law and can help with the IEP process. Oh, one thing I forgot to mention is that whenever you go to an IEP, at least 24 hours in advance of the IEP, send an email indicating that you're going to audio record the IEP. I recommend that my clients use an app called Otter AI. I'm going to stop this screen sharing so I can put something in the chat. Hang on one sec. There we go. So it's called OTTER, A.I. like artificial intelligence. And that's the app. What it does is it audio records and transcribes at the same time. And I have parents use it. You get 600 minutes a month for free. And I get the professional version, which gives me a lot more minutes per month. But what happens is my clients will audio record and transcribe the IEP. The transcriptions are not perfect, but because I know this area so well, I know what's being said. The best part about it is if I am not sure what it was being said by the transcription, I can click on the transcript and it plays the audio recording right where it was recording. So it's a great program. I use it for a lot of different things in my area of the law, but I always recommend parents to audio record your IEP, especially given the fact that people are generally a little more well-behaved when you audio record, but sometimes they're not. And I get some juicy tidbits to take to due process. So that's about it. I would love to answer questions. So we can have you ask questions live or put them in the chat.
I guess some of the questions would be about after COVID, I think that was the...
Oh, I forgot to talk about that. Yes, hang on one sec. So, and this is something you have to be careful about in the LA Unified IEPs. I have not seen it in other IEPs in other districts, but LA Unified has the page in their IEP that says, did the child get all of their services? And if not, they're entitled to compensatory educational services to make up for it. Did the child experience learning loss during the pandemic? And if so, are they entitled to recoupment? There's nothing in the law that talks about recoupment, but this is something that I think the districts made up after the pandemic. Now, there's a 2-year statute of limitations on seeking reimbursement or seeking recoupment and compensatory educational services for a child. And the pandemic, as you know, was more than 2 years ago, but it doesn't prevent a parent, if the child's still struggling and still far behind, it does not prevent the parent from going to due process and going back at least 2 years to get the compensatory services that a child needs in order to make progress. So that's, I know you have to pay attention to that page that's being included in the LA Unified IEPs. And when you, if it just marks that, it checks those boxes and says, child doesn't need this and the child doesn't need that, and there's been no discussion at the time of the IEP, you want to make sure you disagree with it when you sign the IEP. The other thing you should be aware of is when you sign an IEP, you don't have to, it's not all or nothing. You don't have to accept everything. You can agree with what you agree with and disagree with what you disagree with. I never recommend that my clients sign IEPs at the time of the IEP meeting. You should get a document, take it home, review it carefully, because I always see mistakes, and make sure that if you see a mistake that it's corrected. And LA Unified has this thing where if they close an IEP, they can't open it again to correct a mistake. They have to have an amendment, which is really ridiculous. But in any event, it's something that's part of LA Unified's computer program, which is not very user friendly. Did I answer those questions, Sandra?
I think so.
Okay.
I have a question that recently has come up with a few people that I try to assist. Now that we have district BIIs in the IEPs, a lot, because when I talk to people, they're like, "Oh yeah, I do have, my son has a BII." And then reading the IEPs, I realized that the minutes don't match like a full day. And also they say collaborative service, whatever,
Right.
to 1 to 5 days or something, So I'm like, so how is that? That's not a person that's just assigned to your child, but that to me, but I don't know how you.
Correct. This is the thing with LA Unified recently. I'm not seeing this in other districts. And by the way, the term BII and BID is something that LA Unified made up as an acronym. It's not the behavior intervention implementation and behavior intervention development are not terms that you find in the law. But in any event, what they've taken the position lately that a student is not provided a direct one-on-one assigned to that child, because they can work with anybody in the classroom or outside of the classroom. It's one of our pet peeves. We have had a very difficult time with the district saying, we're not going to agree to that. We don't think he has one-to-one needs that require one person to be with this child all day. We think that we're going to teach a child to work with other, various people by having anybody available to be the one-to-one. But, it could be anybody. So, we don't know what the qualifications are of the one-to-one. If it's a non-public agency BII, then you're going to get that person assigned directly to the child. So that's what I would tell parents to argue for. But keeping in mind that the district is having staffing issues and the non-public agencies are having staffing issues. So finding people to fill the job and keep the jobs been very difficult, especially with the non-public agencies. There's a lot of turnover on a regular basis. So I've had a lot of complaints from clients that are saying that, the agency provided one person, that person only lasted 2 weeks, and now they're sending another person, but we haven't had a BII for, 10 days, whatever. I've also had parents complain to me that, their child gets used to working with one person and then that person's gone. So it is a difficult thing. I would tell you that if you believe that your child is in need of a full-time one-on-one, the only way you're going to get it is requesting that he be provided or she be provided an aid from a non-public agency. Just know, though, that non-public agency aides cannot help with toileting and, general self-care. So they can only help with behavior, really. And that you're not going to get a one-on-one aid if your child just needs redirection. If your child has acting out behaviors or is unsafe, that's what they're going to look at.
Mhm. So, some of the new things that I'm hearing is that, oh, your child needs a one-on-one, but we don't have anybody, so you need to keep your child at home, or you can come and
Oh,
spend the day with your child, you know.
that is awful. It's the school district's responsibility to educate your child and not send them home because they don't have anybody to fill the job. They need to find somebody, if they need to pull the principal in, then that's what they need to do, because it's their responsibility. I see this frequently happen with discipline cases. We're sending you, come pick up your kid because he's acting out. And parents will go and do that. But I always tell my clients, if he's not suspended, don't pick him up. They're going to suspend him, then go pick him up. It's kind of the same thing. Just because they don't have somebody that's available doesn't mean that your child has to stay home from school. That's crazy.
Yeah,
Well,
for sure. Let me see if anybody has any questions. Let me try to unmute everybody. I think I can. Well, you can put your questions in the chat. Let me see if I can.
I'm not seeing any questions, but
If you don't have any questions, we can finish our meeting.
I just wanted to recommend.
I do have a question. I'm gonna have an IEP meeting on Tuesday because my child, he gets RSP and he just transferred to middle school. I was forgetting that you mentioned that I was forgetting because I've been so busy with other stuff. I forget that I need to record the meeting, but the IEP meeting is just for me to know about the RSP services because in elementary school is different than middle school.
Mhm.
So that's what I'm gonna have the IEP. But I'm gonna have an IEP, but that meeting I guess it's gonna be like an amendment IEP, isn't it?
Mhm.
Because we're not gonna talk about the goals. We're not gonna discuss levels of performance. It's just gonna for them to explain to me the RSP services for my child. I guess the teachers introduce themselves, and that's it. So that will be like an amendment IEP.
Right. Yes. And it's not going to be an annual IEP. It should only address that issue.
And they should probably document that in some kind of page. Because LAUSD has I don't know, he has so many pages, and some pages they're there, but you don't talk about it. Or they
Yeah.
skip it.
What it should say in the upper, I think, right-hand corner of the IEP is that it should say an amendment to, and then your annual IEP.
Okay.
That's what you want to look at, the top box. It'll tell you the date of the annual, the date of the initial, the date of the annual, the date of the reevaluation. And on the other side, it'll say the date of the IEP amendment. And that's what you want to look at.
Oh, okay. Yeah, but they haven't given me an invitation because I just been talking to the teacher, because
When you get the invitation, you should send them an email indicating you are going to audio record.
yeah, that's usually what I do, so I don't have to write another page. I just, the paper they send me, I just write everything right on the page that I have to sign for the invitation. I just write everything there. So I make it for myself.
Okay.
Thank you. So A has also a question.
Okay.
I don't know.
Hi, I think that's me.
Oh,
Question. Sorry. I'm not sure if it was covered earlier. Can you remind me if there's usually like an IEP refresher at the beginning of the fall school year, or do we have to request that if there were changes that happened during the summer?
You would have to request that. So you would request an IEP to discuss whatever happened during the summer. And that would be an amendment IEP, and they would have 30 days to schedule it.
Okay, thank you. Yeah, because I don't remember from last fall. I felt like it was automatic, but I wasn't too sure. And the change was my daughter is now wearing hearing aids. So it's a pretty big,
Yeah,
it's a pretty big, yes.
Mhm.
Okay,
So-
I'll be sure. Go ahead.
Yeah, I mean, was she assessed over the summer by an audiologist?
Yes, this all happened towards the end of the school year,
Mhm.
and the hearing aids was actually obtained during the summer.
Okay, okay. Do you have a report from the audiologist? I would give that to the school prior to the IE.
Ye- Okay, yes, we do. I have to check if we provided it before.
Mhm.
We have informed her teacher that she's currently being tested and provided the results, I believe, but we haven't told them that she actually has or is wearing a hearing aid now.
Mhm. Does she get any what we call DHH services, deaf and hard of hearing services?
No, this is all brand new to us,
Okay.
so
You
not
might,
yet.
yeah, you depending, I can't really tell you for sure, but based on the audiology report, she may be eligible for DHH services. And so you might want to ask for that.
Okay, on for the IEP request for that
Request that,
along.
yeah, request that they have the DHH teacher. It's usually a DHH itinerant teacher attend the
Mhm.
IEP meeting to
Okay,
discuss whether your child needs any services specifically from the DHH.
okay, great. It doesn't have to be a request to be evaluated for that.
No, you don't have to be, if you're bringing an audiology evaluation in, the DHH department may want to do an assessment, I don't know, but you want to have somebody there that at the IEP that has knowledge of the needs that a child who wears hearing aids might have.
Right. Okay. Good to know. Thank you. So we were just waiting for the teacher to send us the IEP notification, but I guess we're the ones that should initiate it.
Yes, you're the ones that initiated, and I don't know when you joined, but you want to send an email or take a letter over requesting an IEP and being specific with regard to why you're requesting that IEP, and make sure
Okay.
you get a date that you know that you delivered that request, and then they have to schedule it within 30 days.
Okay. Perfect. Yes, I came in about 30 minutes late, but thank you so much.
You're welcome. Okay.
Have a
8. You have a question?
Hi, yeah, I do.
Hi.
I have 2 questions actually. So my son is 3.5 and he's in preschool currently. He's not potty trained,
Okay.
so he wears diapers. And so in his IEP, they mentioned something about, I had somebody who's in that field review it for me, and she called out that they don't have anything to address his potty training, and that's kind of part of daily living and things like that. So I was just curious, and when I had asked them about it, they said he doesn't, something to the effect of he didn't appear to need help in that regard, but he's 3.5 and he wears diapers. Clearly he's behind. So I wasn't sure how to even push on that. We actually changed districts anyway recently, but they're using his old IEP from
Right.
8 months ago. That's
Right.
fine. But I was just wondering about that in general. Does that seem out of ordinary?
No, so you came from one district at the start of a new district in a new school year. This
New school year. So this school year, we're in a new district and they're
Okay.
using his prior school year's IEP.
Right, they have 30 days to provide you with the same services and supports under that prior IEP. And then they have to have their own IEP if they're not going to continue to follow the IEP that you came in with. So you might want to indicate that you would like an IEP meeting to discuss adding a toileting goal to his goals.
Okay. Okay, great. My other question is, as my son gets older, he's 3.5 now, he's not completely nonverbal, but he can say about 4 audible words. And so we are dealing with a significant speech delay. Although in his other IEP, they correlated that to cognitive ability. And I said, they are not related. And I don't know why you're lumping them into one. And that was a red flag. But as we move forward, what I'm concerned with is him being isolated in the classroom. And so I don't know that I want him to experience inclusive education. I don't know that that's the best path for him. I'll know more as he is able to use other forms of communication because he's very creative in that way. However, other children need to be trained how to communicate with him.
Right.
And I don't know how that's going to be facilitated in any classroom.
Lem-
So, yeah,
Is that your question? I'm sorry.
my question ultimately is, if they push me toward inclusion,
Mhm.
and I don't know if I want that, what are my rights to say no? I
Mhm.
want him in a special education class.
You have every right to say no. You can disagree. In California, we have one that they produce a lot of great documents. In one book, it's not really a hard copy, but it's a book, Special Education Rights and Responsibilities. And I love that book because it's written in question and answer form. It quotes California and federal law. And so it's very easy for parents to read and understand. And sometimes I even refer back to it because of that, because it's a great resource. But what I will tell you is the IDEA is the federal law. And here's Law School 101. The IDEA is the federal law. The state law usually mirrors the federal law. But if in any one area the state provides more than the federal law, great, then the federal law would not control. But if the state wants to provide less, then the federal law controls. With regard to your child's communication, how does he communicate with you now?
Pointing, basic sign language. And I know what he's saying because I understand his inaudible language because I'm his mom.
What's his disability?
Down syndrome.
Okay. I would tell you to ask for an augmentative alternative communication assessment. Are you familiar with those?
No.
It's an AAC, alternative and augmentative communication. What they do is it's either a speech therapist trained in doing these assessments or specifically an AAC specialist, and they will do an evaluation to determine the best ways plural for your child to communicate. Because you're going to have what we call a multimodal communicator. He uses different ways to communicate. They will test whether a device is appropriate for him, whether an iPad with an app, and there's a ton of them, they're great, program is appropriate for him. But basically they will make recommendations as to how to best facilitate his communication. Using AAC will not prevent him from developing language. It's just an augmentative way for him to communicate.
And I'm told by a speech therapist that all of those tools actually help them toward developing language,
Yes.
although some parents think that's not the case, but that's true. Okay, that's very helpful. In the AAC specialist eval, is that something I pay for privately, or do I ask the district for that?
You ask the district for that. They should
Okay.
have somebody on staff, but if not, then you ask them to pay for an independent one.
Okay, thank you so much.
Usually the speech therapists are pretty well trained in AAC in this day and age. It used to be that they weren't, and they didn't get any kind of training in speech in augmentative and alternative communication. But there's when they do these assessments, they look at everything from, can your child take a picture from the picture board and give you a picture to tell you what he wants? Can he take pictures and make a sentence? Can he access an iPad? Does he play on the iPad? What about an app on the iPad that works on communication? All the way up to his own dedicated device. So,
Okay.
and just because he has oral language, like I said, does not mean that he won't qualify for a device. No school district does it right in terms of implementing the AAC. They'll do the assessments, you'll get the AAC device, but they don't know what to do with it once they get it. They don't know how to implement it into the classroom so that your child is able to participate. And they have to facilitate other children being able to communicate with him while he's using.
Right, exactly. And that's why I have asked specifically for that feedback and making sure there's an adult facilitating other kids interacting with him so he doesn't just become isolated, because he is in a special needs class, but they are all verbal.
Well, that's probably a good thing.
Yeah, he's trying more since.
Yeah, I'm sure that he is. I mean, because the being around not typical peers, but oral peers, kids that are talking, does help. It does help develop language.
Now, the AAC, you mentioned the device. The device that I was recommended was like about $6,000. My private insurance doesn't cover it. I'm applying for state insurance. It's a process, so I don't have anything yet. I've downloaded an app. I'm going to put it on his little Fire tablet. But did you mention, are they responsible if they determine he needs one? Would they provide that?
Yes, but I always recommend parents, if you get state funding, if you get like our Medi-Cal, Medicaid for in other states, they can pay for it. And then it's your device. If the district provides you the device, they may agree to let you take it home and bring it back, but it's ultimately their device, so that if you still have it and you leave the district, that device stays. And so then you're starting the whole process all over again, right? So I always recommend that parents, if you can access the device through private insurance or Medi-Cal, Medicaid, I would recommend doing that and bringing it into the school district and saying, this is the device that he's been approved for. I've seen some school districts buy their own device and have it at school, and then have the device that he uses at home. The problem with that is they have to sync. Otherwise, if you add something at school, it's not going to show up on his home device. So I know there's capabilities of that these days, but I'm not that technologically savvy. So
Okay. Perfect. That's good information to get me started. I really appreciate it.
You're welcome, and good luck. It's interesting because I have 5 grandkids, 2 of whom are on the autism spectrum, and one that lives in Iowa, and my other daughter lives here. But the one that lives in Iowa is always asking me questions, and I'm like, but I don't know Iowa law. Let's just talk about the federal law. So, but it's interesting because other states are very different than what we provide in California. So, I don't know all the laws in other states.
Sure, but even having these discussions, it gives me a sense of what might be available, and I can at least ask the questions. So I appreciate it. Thank you.
The other thing I wanted to mention is it's important to, when you have if you finally get the device and the assessment device, everything that you need, to make sure that you ask for to train people at school, and also to send somebody to train you and your family at home, because they do that, because it's hard, the implementation is hard. That's why I think that's what the biggest problem is sometimes.
I'm sorry, my dog is barking. One of my dogs is barking. The other one is probably out.
All right. So does anybody else have any more questions?
All good advice in the chat. Prolo Quo to Go is great. Sign language is great. I am a firm believer in whatever's the quickest way to communicate for a child. That's the best way for them to communicate. I've seen kids use amazing AAC devices and are very fast with it. I've seen kids use sign language. I've seen kids use picture communication. I've seen all kinds of things. Kids in general want to communicate with their peers, so they will do anything they can to communicate. So facilitating that is great. Not only Prolo Quo to Go, I don't know if you know this, but it was initially developed by a man whose father had a stroke and couldn't talk. So it's extremely vast. And it really has to be personalized to your child, so that your child's not searching and searching for ways to communicate using the device or using that program. It can be greatly personalized for your child. My son was using that a while, and he did pretty well with it. iPad applications, there's a ton of communication apps, from the simplest one all the way up to more complicated ones like Prolo Quo and like the LAMP Words for Life program. And so you can do some research, and you can also, I'm a big believer in getting AAC assessment, even for kids who are limited verbal, whose intelligibility is difficult. So if you have a child who can speak but can't make, he's not easily understood, then using an alternative means of communication is a good idea. So,
and sometimes, like with my son, because we also use Prolo Quo for a while, but he wants to talk about, it's hard to understand him, and it's important for him to say certain things. So sometimes, okay, this is what you're trying to say. Here's a little flashcard, he put in his pocket, and then, I want to talk about this, and then people, so anyway, you can, it's,
yeah. One of the things that I did when Brandon was little is I took one of those big key rings and I took cards and took pictures. For him, it was easier to see pictures instead of icons. So I took a picture of all of his favorite things, his toys, his bedroom, his bath, and everything, and a toilet. And I laminated them all and put them on a key ring. And so he would take it and he would use that to communicate what his needs were. He was hungry, he was tired, he had to go to the bathroom, whatever. And that started his communication. He has used multiple devices over the years. Currently, he's not using a device. He's communicating using sign language as his primary mode. That seems to be quickest for him. And he doesn't want to use a device anymore because he feels it's cumbersome. But he is at the point right now where he'll answer yes or no questions. But he goes through this period where he'll want something and it takes me hours to figure out what it is because he's like, and I'm supposed to know what that means, and I don't. So, so anyway, it's so interesting when you have a nonverbal child. So my child is completely nonverbal. He can say home, which sounds like om. He could say more, which sounds like mu, and then he says mama and on. He's really good at on, but other than that, he uses sign language. However, the interesting thing about him is he understands English, sign language, Spanish, and a little bit of Yiddish because my husband speaks Yiddish. So he's had Spanish speaking caregivers for most of his life. And it's so funny when my long-term caregiver, her family's adopted him and her parents only speak Spanish and they speak Spanish to him and he totally responds to them in Spanish. And if I try to speak Spanish to him, he looks at me like I'm nuts because I don't have the right accent, right? It's so funny. So, what am I looking at?
Wanted to share my book, where speech therapist gave me this book. When I was, in preschool, he couldn't speak. I don't use it no more, but I was using it for my child with Down syndrome because I have 2 kids with Down syndrome. Like says a picture book, and then they can talk about what they like.
Right. Those are great. That's fabulous. And so you have icons, and sometimes it's difficult for kids to understand icons. So I would take a picture of me smiling, I'm happy, and or me sad, that kind of thing, if they can't understand an icon. And you can always transfer over to icons, which are used in all the communication devices. So was there another question here?
Is the AAC something I have to wait to get done during an IEP, or can I ask for an independent of the IEP process?
Right. What you're asking for essentially is an AAC assessment. And if the district doesn't have a person that's qualified, then they can provide an outside assessor. But what you're asking for is an AAC assessment, not an IEP. You're asking for an assessment. Okay. One of the things that I found for the mom whose child's in preschool, I found that some speech therapists will say an AAC device is not appropriate because the child doesn't have the desire to communicate. Let me tell you, every child has the desire to communicate. So that's not true. And you can absolutely have an AAC assessment for a child who is partially verbal, nonverbal, or unintelligible, or any other reason. So you can make your own books. You can use a like I said, a key ring. You can use a notebook like she had. There are some books that were, gosh, I can't remember. I know the developer's name, but I don't remember the name of the books. Her name is Joan Green, and she developed these reading books that have Velcro little pictures, icons and pictures on them, and they tell a story, and you take the picture and you put it on the story as you're reading it, and they're great books. So it's really good for kids who are just learning how to read, and they can identify the icons. So Joan Green is her name, and I'm pretty sure you can access those books online.
We had a book similar, and they actually also come, I think, color coded. I think the yellow is, I don't know, verbs, and I don't know whatever. And then you have Velcros, and you can make sentences with it and stuff like that.
Right. They're great. Those are wonderful ways to teach children how to communicate. I'll never forget when my son was really little. He wasn't even 3 yet. I don't know exactly how old he was, but he was, I was trying to figure out how he was going to communicate, and he had learned, I thought, some sign language, but we never got an accurate response on a regular basis. So I got him this toy that was, it was like a tiger, and you push the button and the tiger's mouth would open, it would roar, and it had a flashlight, so the light would come on. So he was so excited about it. And I say, do you want more? And he started signing more by doing this, by holding his hand up and pointing to it. And I was like, oh my God, he asked for more, he asked for more. And now it's come to, more. But it was just the way I was able to get him to communicate initially was great, and then he's used every alternative means of communication that there is.
Yeah, my son uses a lot of gestures sometimes. And sometimes he does a sign without even knowing that it's a sign, like umbrella, umbrella,
Yeah.
And
Yeah.
sometimes we do still have times when we don't know what he's saying, but we were laughing the other day. He said it sounded like skinny bagel, like something, but it was telling me that he cooked spaghetti and meatballs. So all that
Oh,
translated into skinny bagel. It's like a skinny bagel to me. but but
funny.
we're like, okay, let me write up spaghetti on this card, and we practice, and anyway, but it's and no matter what age, I think with our kids, a lot of times, because I do know a lot of kids with Down syndrome that have full language,
Mhm.
but at least a lot of like my son and his friends, they all have some type of speech issue,
Mhm.
so we'll try to understand, just
Yeah.
try to understand them,
One of the things that I think would work also for a child who is experiencing learning two languages is maybe you have a picture of milk with milk and leche, if there's learning Spanish, so that they know that milk is leche and that's their picture, that kind of thing. It's difficult for children who are English language learners and to develop language and learn a new language when like Spanish is their initial language, their first language, So I always try to facilitate that. I think it's important for kids to learn both languages if they can. So
yeah. Well, like my son, he's refused. I don't know why. We took him to our country to visit. And after a while, he was like, I want to go back to the United States of America where people speak English,
That's funny. That's funny. Well, I get it. My son would be perfectly fine living in a Spanish-speaking community or country. So,
Well, if any other questions, otherwise, I guess we can let Dina go. Thank you so much, Dina. We really appreciate your time.
you're
Hopefully we can
welcome.
have a little more talks with you often, and maybe, oh, by the way, so Dina has still kind of groups meeting every month. She's gonna send me her schedule, hopefully, and then I can share it with you guys. But I know it was very useful when I started with my son. It started off, and we had, of course, back in the days, it was in person, and we had this round table. So we all came with IEPs, and we had specific questions, and went around the table answering questions and stuff. And I imagine that it's the same thing now, but it's on Zoom. So, but
Yes.
I feel like sometimes we're stuck with something, and once we get like little ideas and stuff like that, I think it's helpful for you to start getting new ideas as well, because maybe an idea that you got from also listening to other people's stories, because this is, I think, how we learn, because maybe this time I'm not having this issue, but I heard somebody who had this issue. So now how this lady resolved this issue now is stuck in my mind. And oh, now guess what? This is happening to me, and I know how to handle this. So I think that's why sometimes it's just very beneficial to attend meetings like that, and you learn so much more. And then so we're gonna do this with our kids all of their lives, and we can get people like Dina, to help. But at the end of the day, we are dealing with daily things at school all the time, And if we know our rights and responsibilities, I think it makes things so much easier, you know.
Definitely.
And I'll give you one example, because I think, at one point my son has such behavior issues that he was, they said that he was expelled from the bus or something. And then I had asked them if they could provide an aid on the bus for my son, and they denied it, whatever. But then I was informed that he was no longer be able to take the bus. So I filed a compliance complaint. And they called me from the district saying, oh, I heard that you're asking for an aid. I tell you, we're not going to do it, And I said, no, I filed a compliance complaint because my son is not getting the bus service, and he's not getting transportation. So whatever, said, well, this is what happened. I know, but whatever transportation looks like, that's what you need to provide. And that's why I filed a complaint. So 20 minutes later, they called me that they have an aid for my son to go on the bus with him. So I didn't have to fight for an aid. It's just knowing what is it that you can fight for. And, I think it's useful,
Mhm.
We will send the PowerPoint. And
Yeah, I was going to tell you, whoever asked for copies of the PowerPoint I sent,
I have it.
Sandra has it and she can send it out to you.
So thank you so much. And anyway, again, so hopefully, so I'll get the dates from Dina.
Well, and also if you want to get put on my email list, just send me a direct email and I will
Okay,
add it to
okay.
the list. I'm going to do it beginning of the week. Or no, wait, we're not quite there yet. Probably the first week in September, because our meeting's the second week in September. I don't like to send them out too quickly in advance because then people forget.
Yeah. So, yeah. And hopefully also, I don't know if you guys are, most of the time, I'm gonna say, Vanaman German have a booth at our Buddy Walk. Our Buddy Walk is coming up November 12th at Santa Anita Park. Thank you
Yes,
so much, everyone, and thank you, Dina, for your time. We really appreciate you, just as
you're
always.
welcome.
We're very grateful you're able to give up your Saturday morning to spend it with us. And
Oh, thank you.
thank you, everybody else.
I love doing this. I especially like it when parents stump me. They ask me a question I don't know the answer to. But I've been around a long time.